I'm here to give you just really a little insight into wills and trusts and asset protection and stuff like that. And for many people I talk to, I open up with the gambit that wills and trusts are pretty boring and we don't really want to talk about that at all. Okay, because wills is about death for a start off. We don't want to talk about that. And trusts, well, aren't they some fandangled sort of thing that's not applicable to me in the slightest, because that's for the really wealthy and gentry and it's nothing to do with me at all. On talking to clients, I'll talk about protecting their assets though, and I'll go into some of those issues that we could be talking about in terms of what we're protecting. Okay, it just so happens the vehicles to protect the assets that many of us, I'm sure, hopefully will be perhaps relate to some of this stuff. The means of actually protecting means having the right wills and trusts in place. Okay, so there I am officially. Okay, as to who I am, I'm the Senior Technical Advisor at Countrywide Tax and Trust Corporation, say based up in the Midlands. There's a few letters in after my name, but the one that possibly we just need to be a little bit mindful of, or just be more aware of, is the STEP one, and I'm a STEP affiliate. Now the STEP is the Society for Trust and Estate Practitioners, and I must confess, because I know there's a fully TEP qualified individual in the room, I'm just an affiliate to date. But I've been working at Countrywide Tax and Trust Corporation for over 6 years, and our ethos, or what our business is estate planning and protecting people's assets. Okay, we're not. Some of you may have heard of a different Countrywide that deal with estate agents and conveyancing and stuff like that. Absolutely nothing to do with them. Okay. So who are Countrywide? Just to give a little bit of information, we've been around in its entirety for over 10 years now. And we're owned by two directors, which I think you've got some information about. Bob and Clive, some of you are looking at that at the moment. They are the owners and full directors of the company, and they are indeed fully STEP qualified advisors. Okay. We also have further members within the company who are also fully STEP qualified, and as you can see, a merry band of us who are STEP affiliates who've gone some way with the qualifications. STEP, the Society for Trust and Estate Practitioners, is sort of deemed to be the sort of the Premier League, shall we say, within this sort of environment of estate planning, and it's a worldwide recognised qualification, and there's only about 14 or 15,000 worldwide fully STEP qualified individuals. So we like to think that's, as I say, the Premier League of where people need to be with this in this world. We're not solicitors for a start off, but as you can see, we actually employ solicitors. Okay, we're a tax and trust corporation, and that actually means we can work as professional trustees. There's various criteria that we have to make and meet, both financially and otherwise, to be called a tax and trust corporation. But I won't go into a massive amount of that sort of detail for you this evening, if I'm honest. And as I say, we're based in the Midlands, in Kenilworth, but as you can see clearly, we cover the whole of the country. So here I am, 2.5 hours away from home. What do? We actually, just to give you a flavour as to what we're about, we establish a lot of wills and trust documents per week. We're quite a reasonable player in this industry, and we do the creation of the documents. And as you can see, we are dealing with a whole host of financial services individuals, will writers, accountants, clearly, as tonight includes, and indeed we also deal with further solicitors as well in the country, aiding with their estate planning arm as well. This is always an interesting thing to throw into the mix early days. 70% of the population don't have a will at all. So I don't know whether I should dare ask the population in the room, because probably about, believe it or not, 70% of you may not have one. Do you have a will, anybody? Yep. Hey, not bad at all. That's better than the 30% that do. Excellent stuff, that's a good sign. Okay. Obviously 70% of the population don't have a will at all. They're then going to be dealing with what's called intestacy laws. Okay, and I'll touch on that very, very briefly in a second. And then the 30%, which clearly we have a bigger number here, do have a will. But my bigger question then too, is it doing what you really want it to do? In my time at Countrywide, just to give you a little insight, as I say, over 6 years, I probably have analysed, I would reckon, conservatively, 1 will a day in my working career. I have not yet seen one will that I can't improve upon, insofar as it's not providing all the possible protection that there is available, that we can provide at Countrywide. take that of what you will. Okay. We'll just have a look at the intestacy side of things. This is where somebody's decided that they're not going to perhaps establish a will at all, or not even thought about this, because I find a lot with talking to individuals, they would think, well, everything's just going to go to my surviving spouse. Bit of a misnomer, okay? That is not necessarily the case. If there's a spouse and some children involved when somebody passes away and they haven't got a will, the surviving spouse is actually only going to inherit the first £250,000 of the deceased, okay? He or she will only have then a life interest in the rest, okay? The kids get the other bit of the half, if you see what I mean, okay? We know of case law whereby we have a surviving young married mother who is currently suing her minor children because her wealthy husband, when he died without a will, sort of left her in the world where she's not now accustomed to the wealth that she's now inherited. Okay, it's a real reality. Many people think everything's just going to go automatically to the surviving spouse. That is not the case. It's still also the case if there's no children. Okay, he or she will get the first £450,000 of the estate, and he or she will then get half of the rest of that. And as you can see, the rest of the estate will end up either going up to parents, across to brothers or sisters, or even to nieces and nephews. And if there are none of them, actually then is when the spouse will get the rest of it. So you're leaving it to chance. And that's whether you like them or not. Okay? Can't pick your family. Now, a lot of the stuff I see in terms of wills, when I'm analysing, are that top one. I'm going to leave everything to my wife. A standard will. Okay, that's an absolute gift, as we say. And there's a whole host of that sort of stuff out there, no problems at all. Now, the alternative we can look at is what's called a trust. Like a bit like a treasure chest, I suppose, is a trust. Okay. But the issue with these standard wills that people have, I just need everything to go to the surviving spouse, and if he or she's not there, I'll go to the kids. That's all I need it to do. That's fine. Okay. Well, the issue is with that setup, there is absolutely no protection at all. No protection of the assets at all. So what do I mean by that? Okay. If there's perhaps anything you want to take of anything tonight to make it worth your while, I would highlight this screen to you. Okay. That is, if I pass everything to my surviving spouse, okay, if she goes down the road and remarries, okay, what she inherits from me, which granted wouldn't be a fat lot as it stands today, okay, would be at risk from her new marriage, her new fella. Which, to be fair, I wouldn't begrudge her the happiness and all that sort of stuff again if I'm not around. Okay, good luck to her, good luck to him and all that. But what I'm not enamoured by the prospect of is that he will benefit from what I've passed on to my spouse. And indeed, if he comes along with his kids, I'm not enamoured by feeding them. That's my marriage after death situation. Okay, don't know if that'd be a concern to some of you. The other one, of course, is at the top. If she does remarry, clearly she will figure out the new fella is not as good as the last one. Okay, and there could be a divorce. Do I want half of what she's inherited from me going to that fella just through the divorce? No, I don't. Do I want to leave that to risk, to chance? No, I don't. Okay. Bankruptcy, creditors. She likes a pair of shoes and a handbag, does my wife? Happily goes and spends a fortune on them on the credit card. Do I want what I've worked hard for to be just paying off the credit card bill? No. Or she decides to set up a business and it goes horribly wrong. Do I want the creditors coming after everything that she's inherited? No, I don't. Do I want to leave it to chance? No. For many clients, long-term care fees. If I pass everything on to my spouse, hopefully I've got a good 30, 40 years in me yet. And inevitably, fellas, we're probably going to go before our wives. And sadly, our wives then end up in a care home. Do I want that to pay for care fees if I can avoid it? Well, yes, I would. But if I've just left everything to her, it's at risk. Okay? Now, I'd also hasten to add, it all is very much the same for my children. So if my children inherit from me, am I enamoured by the prospect of, I would have daughters-in-law? Am I enamoured by the daughter-in-law taking a claim on half of what my kids have inherited? even if I did like them. Okay? No, I don't want that to go to sons-in-laws and daughters-in-law. Okay? My standard will won't provide me much protection for that. Similarly, their creditors. My children inherit now in their early 20s and late teens. Heaven forbid me and the wife have gone suddenly, and they've got a reasonable amount of money from life policies and things like that, all at risk from their creditors. What would we have all done at the ripe old age of 18 and 19 and 20 with a couple of 300 grand in our back pockets? Would we like to protect it against their creditors and then blowing it on the cars and the booze and wasting the rest of it? Okay? And their, as I say, their daughters-in-law, sons-in-law. Okay? Also the issue as well, the very bottom line, if I'm honest, is inheritance tax. Because I think the other things are bigger issues and bigger concerns. There's certainly bigger percentages. Inheritance tax could be 40%. A beneficiary's divorce could be 50%. Bankruptcy and creditors and care fees, there's no limit really as to what could be lost. So it's more, it could be up to 100% perhaps. Inheritance tax is just 40%. But similarly, if I pass my assets on to my children, it increases their estates. They may have gained their own wealth in their own right. There's many calculations that we've done of estates falling onto children's estates who've also got a reasonable size themselves, that when they pass away, in just 2 generations, the largest sole beneficiary of the estate was the taxman. Okay? Now, to all of us, or those of you who have got clients of your own and things like that, would any of these things be an issue to you or to them? I would guess, I'll stick my neck out, a good proportion of us in this room at least could say at least one of them may be something that, actually, that's a concern to me. I won't ask everybody that, but nonetheless, it's something to think about. Okay? That's our standard will. What alternative we got? Then we've got the use of trusts. Okay? Just going to give you a little illustration as to how these things sort of work. Okay? We've got a Mr. X, and when he's passed away, sadly, £250,000 has gone to his trustees. Okay? And he's chosen who they are, actually. He's got his spouse, and we maybe got somebody professional to help him out with that as well, professional trustees, perhaps a tax and trust corporation. Okay? And quite naturally, he suggested who he wanted to be beneficiaries of that trust. His spouse and his children and future generations, quite rightly. Okay? Now, if his spouse gets remarried, just a very quick question to you, how much do you think of that £250,000 is at risk? Anybody want to guess? A few shakes of the head, a few saying no. Thank you. Excellent. None of it. That seems quite a good idea. Okay. How about then, let's have another look at a scenario. One of the children happened to be married and sadly gets divorced. How much of that fund is at risk from the divorce? None of it. Meanwhile, child number 2, he goes bankrupt, he's got a business. How much of that trust fund is at risk? There is a common theme with these slides, just incidentally, just to give you a hint. None of it. Okay? Number of years later, sadly, child number 3 goes into a care home. How much of that £250,000 is at risk from the care fees? None of it. I hasten to add, they seem like the most unluckiest family in the world at this stage. One of the children has now sadly died. How much of that £250,000 is in their estate for their own inheritance tax? None of it. So these things seem quite a good idea, these concepts of trusts. Okay? They've been in existence for about 1,000 years, don't you know? Okay? The land and the wealthy, back in the days, they were using these. It's just now, only in these last couple of generations perhaps, that we all now own our little bit of land. Okay? Whether it's some lovely place down in the southeast or an £80,000 4-bedroom house in Coventry from where I'm from. Okay? We all want to protect it, as a rule. Talk about bloodline planning. I want to protect my assets from my bloodline. So just to give a little illustration here, we've got an example of Mum passing on monies to her two children, £300,000. Okay, could actually be during her lifetime. She might want to help them out with getting onto the property ladder and stuff like that. Come across a lot of that at the moment. Well, the issue is, daughter, for example, she's got £150,000, and the daughter divorces from the outlaw, as we call him back at Countrywide. Just because of the circumstance, he could walk down the road with half of what she was given. 75 grand. It's not too shabby. It might be in the very thing he'd been waiting for. I've come across that before now. Okay. Similarly, son may have a business. With his £150,000, of course, from the creditor, could be no limit. Could be well and truly up to his neck in it. Well, the creditor would be more than happy to receive that £150,000 to help pay off the debts. Okay, so that's our bloodline planning. Big issue that many clients want to talk about is long-term care. It's been in the media and the press a lot recently. Headline news in lots of cases. How should the state be protecting and paying for people's care fees? What some of you may have come across, there's actually limits. If anybody has got over £23,000 odd pounds, then they're on their own. The local authority aren't going to contribute anything to care for that individuals. And it's only once you've got down to those limits will they then even start to possibly contribute something towards those care fees. So arguably, the issue is when we come to sadly need care home, we need to possibly have assets in our ownership that are less than the lowest threshold, which at the moment is 14,250 in England. Okay. So, can we achieve that? Well, we've got to be mindful of a few things. We can't just give everything away. If the day we're expecting to go into a care home, think, oh crikey, I'll just give the house away, and then it's not mine to be accessible. Well, funnily enough, the local authority don't like that. Okay. So we've got to be really careful if we've got to start considering giving things away. However, what we find, a lot of the reasons why people are losing lots of assets through care fees is actually how they own assets in the first place. Very often, I mean, there's a lot of statistics put out there in terms of the number of properties that are sold to pay for care fees. I've heard anything between 20,000 a year and 70,000 homes a year paid for care. Now, if it's 20,000 homes a year, the very conservative end, that would mean over the course of today, nearly 60 homes would have been sold to pay for care fees. But I think the estimates are really, it's a lot higher than that. Okay? Generally speaking, it's because the consequences of how a lot of us own our homes as a couple. That we own the house jointly. People own houses jointly? Show of hands, perhaps? Right, excellent. I say excellent. Little hint and tip, don't own it jointly. You don't own anything jointly with anybody. Okay, bit of free advice for you. Okay, what does joint ownership mean then? It sort of means that we own the house 100% each, in a way. So what actually happens is us fellas keel over first and foremost again, okay? And our good ladies end up owning the home solely, irrelevant as to what planning we've got in place. Could be the best will in the world, to coin a phrase, okay? Our good ladies have now inherited the home, brilliant. She gets into her 80s, bless her, and she needs to go into a care home. Clearly she gets assessed. Inevitably it's valued over £23,250. And the local authority, you're on your own, love. Sorry, we're not paying anything. And this is where the homes get sold to pay for care fees, just purely because of how we own the home. Okay? What we should do, again, a little bit of free advice for you, own your homes as tenants in common. An easy scenario to sort out, okay? Now what that means, you can own a part of the house. You don't change the land registry title, you're still on the title with the other half, Mr. and Mrs, no problem, okay? But you're now declaring you actually own a bit each. There we go, so we split it out. You're still on the title, you can still move, you still have your mortgages if you've got those things. Mortgage lenders aren't bothered, okay? So what now happens when us chaps pass away, our will now can direct that where we want it to go to. Now clearly we don't want to do it absolutely to our surviving spouse because we're back to square one again, aren't we? So what we need is one of these things called a trust. or 2 or 3, depending what values we're talking about. Okay? So sadly we've passed away, fellas. Our share of the house now can go to this trust, for which, clearly, our wife and kids can benefit from it. No problems at all with that. And there's a distinct likelihood, in fact, actually, the surviving spouse could be can be in control of it by being a trustee. Because we trust her, hopefully. Okay? So she can decide, yeah, I'm going to still live in it. Or she could say, I'm going to move. There's no problem, but the house is now in trust. Now, the question is, sadly, the surviving spouse now ends up in a care home. Question to you, what do you think is now the value when she gets assessed for care of that home? Half of it. Okay? Anybody else? Nothing. That's not our rules at Countrywide, I hasten to add. None of this is our rules. This comes from the Department of Health. Central government, in essence. Big, lengthy, horrible document called the Charging for Residential Accommodation Guide, CRAG for short it's called. Now what that basically says in that little section there is that to the guide to local authorities is that you have to consider, local authority, what is the market value of that part share of that house. Okay? I'll ask a question to any of you. Would any of you buy half a house? I don't know if there's any estate agents in the room. Are there any estate agents in the room? Yes? No? Can I ask you, do you sell halves of houses? Not regularly, no. I don't reckon you've sold one. I'll not make you, sir. Not half of one. Because there's no value, is there? Okay? So by having the right planning in place, okay, we can protect the consequences of the survivor going into care. Just how by getting the right advice from the advisor. Okay? Now, just a little question out there to you. I talked about deliberate deprivation, and there's some time scales and all that sort of stuff relating to deliberate deprivation. Quick question, and maybe a little bit technical. Do you think she's given anything away when we did that? Answer is no. She didn't give anything away. Okay, that's what deliberate deprivation is about. The local authorities say, have you given anything away to avoid paying for your care fees? No, she hasn't. It's only her that can be assessed. Sadly, her husband's passed away. That's all that's happened. And quite legally, he's been able to direct what he owned to a trust environment that's been, the concept of which has been around for centuries, 1,000 years or so. Okay? So arguably, we could do this planning on a Monday. Sadly, there could then be a death on a Tuesday. By the end of the week, the surviving spouse is in a care home and it's protected. Okay? There's not many people out there who've got this sort of planning in place. Many, many people are concerned by care fees though. So there's our information there. Little entity, won't go too technical here, but some people are saying about if we both end up in a care home, there's an empty house then, and clearly there's a market value for our estate agent to sell. So is there anything we can do about it? Funnily enough, there is. And funnily enough, we're going to use some trusts. Basically, whilst we're alive, hopefully well in advance of us needing any nursing care, if we're really concerned by, want to cover the risk of us both ending up in a care home, can we do anything about that? Yes. Let's create a trust each, let's say, today. And we'll do some legal work to move our house to the trustees, for which we can still be trustees. We can still be in control. We can still benefit from that trust and live in it. No problems at all. But we are bringing in people into this world of deliberate deprivation, so you just need to do it well in advance, at a time when there's no reason to think you're going to go into care. Okay? Again, something that, when talking to your advisors, you can get some more detail on this. Okay? I hasten to add, I've put a note at the bottom there, don't give your property to your children. There's bucket loads of that out there. Okay? Reason being, because it's now increased your children's estates. It's at risk from their divorces, creditor claims, care fees, inheritance tax. Okay? And probably on the basis that they're unlikely to be living in that house, when you sadly pop your clogs, ladies and gentlemen, your children will then probably sell the house and get hit by capital gains tax as well. But apart from that, it's a cracking idea. Okay? Again, just be mindful of deliberate deprivation when you're giving things away. Okay? So we've dealt with that. Can we do anything with cash and investments and stuff? Yes, we can. Funnily enough, we'll use a trust again. And I can put assets into a trust, just like I did with my house, for which I can still benefit from. I can still control it because I'm going to be a trustee. That was, in probably about 20 minutes, a sweeping insight into estate planning and the concept of possibly considering trusts and considering 5 issues. Are you bothered by the remarriage of the surviving one of you, care fees, or bloodline, our children, the loss from outlaws from hell, okay, their creditors, their care fees, and in time their inheritance tax, okay? And the guys at CBHC can give that advice to you about that. Another important element to also look at and to consider, again, free bit of advice for everybody, every one of us should have a lasting power of attorney in place, okay? A lasting power of attorney is a legal document that can enable you to appoint people to look after your affairs should you lose the capacity in time whilst you're alive to deal with your own affairs, be it financially or indeed your health and welfare. Okay? Every one of us should have that, because the issue is if we lose our capacity through any reason, heaven forbid some horrible accident, okay, it doesn't have to be through elderly age, which is the common perception is what's going to happen. Okay, it can happen at any time, because if we lose our capacity, our next of kin, our spouses, our children, have absolutely no legal rights to deal with those affairs. The only way that anybody can put themselves forward to deal with those affairs is to have to go through the courts to get appointed. And I wouldn't wish that on my worst enemy if I knew I had one. Okay, because it's horrible. You go through the courts and the courts will appoint who's appropriate, and then you'll be called a deputy. Okay, and the deputy, I suppose it's called a deputy because you'll be continually supervised by the courts. Horrible place to be, and not the cheapest thing to do either, I hasten to add. Okay, because you've got to pay fees annually to the courts. Every time you've got to go through the courts to get agreement as to what you can do, you've got to pay for it. Okay, the courts will decide how much supervision they will have over you. Okay. The courts are classically known to limit the amount of monies that you can sign for that person who's lost capacity. So it could be paying for school fees, university fees, care home fees. Okay? And as it says there, major decisions such as trying to sell property to possibly pay for fees has to get agreed by the courts. Okay? The deputy also has to provide almighty amount of information about themselves and their family and their financial situation. Okay? I've heard some very tragic circumstances and stories of people who have not got powers of attorney and somebody has ended up unable to look after their affairs and the family members have tried to act in their best interest and they have had no power to do it. As I've noted, there are 2 elements. Property and financial, lasting power of attorney, and health and welfare. Every one of us should have it. And within health and welfare, you have what's called an advance directive, which, without getting too gory about it all, is basically like a living will. You can give guidance as to the medical profession as to how much involvement and what you would want them to do or not in case of having to turn off machines and stuff like that. Okay. So there we go, a lasting power of attorney. You can choose who you want to look after your affairs. Classically, people say, I'll have my spouse, I may have the kids as well, or have the kids coming in time and all that sort of stuff. Really important. Okay. Obviously, you can expect to have to pay to get these things in place, and we would also recommend these things are registered because they can't be used by the attorneys until they're registered at the Office of Public Guardian. Okay. But as you can see, going forward, there would be then no continuing involvement with the courts by any way, shape or form, no fees to pay at the courts, there's no involvement at all. You just have this powerful document that now the attorneys can work in your best interests through the banks, financial investment, all that sort of stuff for you, and make decisions about your health and welfare. Okay. And as I say, no supervision from the courts at all.